Welcome everyone. My name is Denise, Loraine, and I'm the State Manager for Empire Careers and Legal Eagles. We're delighted to be here tonight in partnership with e.law. A little bit about us. Empire Careers and Legal Eagles are a well-established national recruitment agency. As part of our name would suggest, we are specialists in legal recruitment and provide clients with both temporary and permanent staff. We supply qualified lawyers right through to legal representatives for most of our legal firms here in Melbourne, and really anything in between. We have successfully supplied staff for royal commissions, class actions, and litigation projects. More recently, under the banner of Empire Careers, we've successfully placing candidates with commercial clients and have established a finance and accounting team working alongside our admin support teams and shared services teams. We'd be delighted to assist any of you with any of your recruitment needs. Our panellists this evening are very well qualified and bring a great deal of diversity to this discussion. I'm sure that you will all agree that product liability class actions remains a hot topic, and tonight will give us an opportunity to discuss many of the issues surrounding these claims. We would like to welcome our first panel member for this evening, the Honourable Justice Donnell Ryan QC, a legal expert who is admitted to practice in Victoria and New South Wales. A nationally accredited mediator, he has served as acting chairman at the Victorian Liquor Control Commission, been senior counsel assisting the Hope Royal Commissions into Australian Security Organisation. So covering a variety of areas within law, he brings a wealth of knowledge and expertise to the table. Welcome. Our next panel member is Annette Hughes. Annette is a partner at Corrs Chambers Westgarth. With 25 years' experience, Annette is an expert in her field. Her solutions are much sought after and her advice is greatly trusted. Annette is known for a practical, strategic advice and a cool head when stakes are high, which we will be relying on tonight. Julie Clayton, welcome Julie, principal lawyer at Slater and Gordon. Julie's strengths as a lawyer are her honesty, good judgment and compassion. Helping clients deal with stressful situations and getting the best possible legal outcomes are all in a day's work for Julie. Julie is unwavering in her responsibilities to give clear and correct advice and make sure that her clients truly understand what options are available to them. Next, I'd like to welcome Kate Burke. Kate is a barrister at List G Barristers. Kate has appeared in numerous group and multi-party proceedings and practices in a wide range of commercial matters. Kate regularly acts in consumer litigation involving goods and services, particularly professional services involving financial planners, lawyers, valuers, and accountants. Last but by no means least, I'd like to welcome Kylie. Kylie Petersen is the Director for Consulting and Services, e.law International, and our partners here tonight. Kylie is a lawyer with both private practice and in-house experience. Working with litigators across Australia and New Zealand, she provides strategic and practical advice on the implementation of best practice solutions for technology-driven evidence management. Kylie has an in-depth understanding of the commercial needs of litigators and the solutions that can be offered by current technologies. I'm sure that you will agree we've got a great panel here tonight. Again, I'd like to thank all of you for joining this evening for what I'm sure will be an interesting and informative evening. Over to the panellists. Thank you.
Well, thank you for that introduction and welcome everyone to this evening's roundtable discussion. I'm sure there are some people in the audience who were at the corresponding function last year, and this year has been a very significant one for the development of class actions in Australia. There have been the major settlements of the Victorian bushfire litigation, which has resulted in the establishment of funds which are still being, or in respect of which claims are still being assessed and are being dispersed under the supervision of the court, the Victorian Supreme Court. There's been an instructive judgment of the Supreme Court about the role of solicitors and litigation funders in relation to class actions. And I'm sure you'll hear tonight from our panel members about other developments, particularly with a focus on product liability, which is the theme of tonight's panel discussion. So you'll see in the material that there are some questions which have been formulated as requiring, in the view of those responsible for putting on this discussion, some answers and some in the hope that they will provoke further discussion. But I want to encourage anybody in the audience who is provoked by anything that's said tonight to raise that at an appropriate time so that our very experienced panellists can deal with it. So without further introduction, I'll take you to the first of the listed questions and throw it open to the panel, which is to ask how does a product liability class action differ from other forms of class action? And I've mentioned a couple of others. One of the forms of class action that's attracted a lot of attention in recent years has been the shareholder class action, and that was very largely the focus of last year's presentation. But tonight the focus is on product liability. So I'll ask each of our panellists to give her view of the difference between a product a class action seeking to recover damages for product liability as opposed to the other types of class action, some of which I've mentioned.
It seems to me that one of the main differences, or one of the key differences for the purposes of tonight's discussion, is when you're trying to establish causation in a product liability matter, individual issues can predominate the debate in front of any court. And so the sorts of large-scale recoveries that are easier to get and more attractive to finance are not going to be in the product liability arena as a general principle. And I think that we saw this played out in the Vioxx class action, for example. The way that the class action proceedings operate here in Australia mean that that's not so much of a barrier as it might be, for example, in America. But it also means that the upside of damages that drive product liability cases in America, which don't exist here, can't sort of nudge along a bit of blindness to that problem. So in my view, the reason why we haven't seen as many of the larger product liability class actions in Australia yet is because, if I could use that horrible term, low-hanging fruit, I think a lot of litigation funders have been focusing on more in the securities area and misleading and deceptive conduct of a different nature, or continuous disclosure, for example, where it's easier to establish in one fell swoop a killer of a liability issue and extract a large settlement. I think that's one of the things that's important to note.
Thank you, Kate.
I agree with that. I just finished working on the Bonsoy class action, which I think is probably one of the more recent product liability class actions in Victoria. And then a couple of years ago, I did shareholder class action. The causation, the differences in causation between those two cases were profound and had a significant impact on how damages could be and were assessed, which of course feeds in to risk and to settlement negotiations throughout the process. So, I mean, class actions are, of course, if you say, as I do sometimes, oh, I do class actions, it doesn't really tell you anything. It's a procedural advice. It's like saying I do litigation. It doesn't tell you anything about the area of law. Product liability cases generally involve, they can and do sometimes involve statutes, but I can't think of a product liability case that doesn't have negligence or perhaps other torts involved in it as well. And that's really where the difference lies, is dealing with the common law and dealing with the issues that arise out of that law, and not just about causation, but of course the impact on damages, the thresholds that are required to obtain damages under the Wrongs Act or under the New South Wales legislation, even under the consumer law, are a real hurdle, I think, or something to be, well, they're a hurdle, something to be gotten over. And then, of course, once you have gotten over that threshold, you have to deal with the caps on damages. So all of this adds a layer of complexity that I don't think is quite so present in a shareholder class action, where it is easier to estimate and prove your damages. There might be a couple of different methodologies, but everybody understands what those variables are. You can pop them into a spreadsheet and say, okay, well, we've got a range of 1, 2 and 3. When you've got a group of injured individuals, I'm yet to see a spreadsheet that can deal with that effectively, and if there is one, it's probably needs to be updated 2 seconds ago and would take some poor first-year lawyer about a year to put together. It really does, it really is a completely different dynamic. So I think that the key difference is in the area of law, and how when you're looking at a class action, that the scale of that problem becomes much more of an impediment to speedy resolution, for example.
Yes, thank you, Kate. Julie, do you have a view about that?
Yeah, look, I agree with Annette that the low-hanging fruit for litigation funders may well be the sort of shareholder, easier to assess, easier to resolve type of litigation. But if you look back historically at class actions, before, for example, the changes to the Wrongs Act, the class actions mostly were personal injury and very often defective product or trade practices, as it then was, sorts of claims. So back in the kind of good old days, and I'm showing my age here, we had a spate of food contamination claims, for example. Grant Ryan and the Great Lakes Council was the contaminated oysters with hepatitis C. And that was a case that did include elements of negligence, but we actually lost on the negligence, and we even lost on the defective product aspect of that claim, because although you would think that it's without argument that an oyster that has hepatitis A is a defective product, there's a defence to the defective product provisions, which is that if it can't by science or technology be discovered, then it's deemed not to be a strict liability provision. And in that case, it was determined that to test the oyster, for example, for hepatitis A, you had to destroy the oyster. And so the court held that that effectively was not able to be discovered. So the way that that case ultimately got up was only on the unmerchantable quality and those sort of, if you like, lesser aspects of the class action, of the trade practices regime. So I think that there is a history of defective products, product liability cases, and I think what makes it difficult now is, as Kate correctly pointed out, the institution of the Wrongs Act threshold impairment levels. So you can't even bring a claim unless you can satisfy that you've got a permanent injury, and most, for example, food contamination cases are not going to render you permanently incapacitated. So that makes it difficult. There are obviously complexities around the individual causation issues, and Vioxx, unfortunately, a case I'm also rather familiar with, shows how difficult that can be in practice. You can win one person's case, it doesn't do anything for the rest of them who still have to prove their individual causation, and then you can lose that person's case on appeal and make it extremely difficult for the rest of the group members to be able to resolve. But having said that, there are class actions. Bonsoy, the Fairbridge settlement in New South Wales just announced this week, and other personal injury class actions that do settle without verdicts, and ways are found to assess damages and so on. So it's not an insurmountable problem, but it definitely makes it, I suppose, less attractive to litigation funders and more of a long-term investment for law firms to take on.
Yes, do you have a comment about that?
Well, I was just going to make the comment, obviously I'm going to speak from a technology perspective tonight, and I mean the other panellists have discussed the unique challenges and hurdles and impacts of caps and the like that mean that the reliance on technology just is relied upon to really deliver cost efficiencies and time efficiencies and just a greater degree of efficiency than perhaps is required in a class action of another nature. So there's just more pressure on the technology to deliver advantage, and I think it is uniquely positioned to do that.
Good. Well, thank you for that, Kylie and Julie. That leads into the next question, which is how effective have product liability class actions been to date in Australia? Do you have a view about that then,
I guess
Julie?
it depends on how you're measuring effectiveness. If you're measuring effectiveness purely in terms of, sort of dollars delivered to the people who are bringing the claims, but the punters, it's open. Some win, some lose, some settle well, some settle poorly. But if you consider effectiveness in terms of access to the courts, access to justice, access to a claim that otherwise mightn't exist, then I think there's no doubt that they're extremely effective. And the reason for that is that, it just very rarely is going to be worthwhile for an individual to take on, for example, a multinational food company like Bonsoy over their own injury, where the cap on damages is going to be, $500,000 for your general damages. You might not have a loss of earnings. So to sort of launch $10, $20 million, I've got no idea what it cost, but that level of expenditure, when your recovery is only going to be modest, your solicitor client out-of-pocket expenses are going to, mop that up, even if you're successful. So in terms of just making it actually achievable for people who otherwise wouldn't be able to bring claims, then I don't think there's any doubt that they're effective.
I might sort of add a little bit to that and then segue into the next question, because in my mind they're linked a bit. And so building on the comments that Julie made, I agree that product liability, class actions in the product liability arena have the capacity to be extremely effective, but I don't think that they've been as effective as they could be in Australia, and I think that that's in part because of the access to justice issues that we've been talking about already in response to the first question. I'm going to be somewhat controversial for a partner at a large commercial firm that generally acts for defendants in this area, and say that I think that if we removed some of the barriers to access to justice in this area, that they would be much more effective at regulating corporate conduct and much more effective at assisting, if I could put it that way, the ACL in doing its job. So the Australian consumer law, which is what the next question deals with, has a lot of mechanisms to help regulate the behavior of people who put products into the market. But the body that implements that, there are several bodies that implement that, but for the purposes of tonight, I'm going to talk about the ACCC because we all know about them and they're easy to talk about. There are limited resources at that body. For example, the ACCC at the moment is having trouble even keeping up with its mandatory reports and responding to Section 128 notices regarding recalls because it's just under-resourced and there's too much going on and not enough people to deal with things on the product safety team, and they work very hard. But they're one body enforcing a body of law that applies to a huge range of products across a huge range of sectors across the country. And what we've seen in some other jurisdictions, and given my accent, it won't be surprising that I'm going to pick on the Americans. Yes, there are some disadvantages to what some might see as extreme access to justice, but we've seen the tort system and the class action system and the legal system sort of augment the body of laws that regulate products in that country to allow broader access to justice to drive behavior. And maybe the pendulum swung a little bit too far with our American friends, but I think it'd be nice to see the pendulum swing a little bit that way in Australia and just allow a bit more of driving. And if I could just throw out the term contingency fee into the discussion, I think deregulating some aspects of how funding of litigation is permitted to occur. I can't see a reason for distinguishing between litigation funders and lawyers' firms in terms of being able to finance litigation and take on risk and share risk with clients, as long as there are adequate measures to protect the client's rights, independence, the right sort of judgment, professional standards. All of those things act as a check to what can be a contingency fee beast gone wild. in this jurisdiction, it's different to America in a good way in that way. So that's a bit more perhaps than you intended me to say, but
thank you
I do
anyway,
that sometimes.
Annette. Well, the next, as Annette
Can I
is...
just add
oh, sorry,
something to that?
yeah.
I've been inspired now by Annette's comment about the role of a class action generally, and in particular a product liability class action. I think they do play a role, and they are quite effective as a sort of form of private regulation. And this is a concept that comes up a lot when talking about class actions. But your comments about the ACCC and their inability through resourcing problems to properly police these areas. It's not just the ACCC. In Bonsoi, where the Food Safety Authorities discovered that this soy milk was chock full of iodine and had been for 6 years. And they discovered it because a newborn baby was very, very, very sick. And if they hadn't been caught, she would have grown up with terrible developmental problems. So the Food Safety Authority in New South Wales and Victoria, and then all across Australia, got together on Christmas Eve and issued an emergency recall. And this product was taken off ships and buried. Really serious stuff. But after that, there was nothing. There was no prosecution of Spiral Foods or of the Japanese manufacturers by any of the food product or the food safety regulations across Australia in any of the states or territories, or nationally by food safety and the New Zealand and Australian counterparts. So without the class action, the punishment's not the right word, but the investigation into what happened and why would not have occurred. And arguably, that is a sort of private regulatory role that class actions can and do play, that I think is very important and is a measure of effectiveness. I would be astonished if Spiral Foods or any of the other defendants in that case hadn't put in place very, very different systems now to make sure something like that won't happen again. And not just, of course, for those parties, but for their competitors in the same field.
Yes, well, thank you, Kate and Annette. As Annette foreshadowed, the next two questions deal with the Australian consumer law. That is the Act which replaced, as Julie mentioned, the Trade Practices Act. I think it's probably appropriate to run those two questions together for the purpose of discussion. They are: what type of role does Australian consumer law play in product liability class actions, and what sort of obligations has the law placed on manufacturers and suppliers to reduce product defects? So if I can throw that question open to our panel again. Do you have a view about that, Julie?
I'd probably lean towards saying it doesn't play a big enough role, and the reason that it doesn't play as big a role as arguably it was intended to is because of the imposition of tort reform. So where you have a defective product, theoretically under the legislation, you should be able to bring a very straightforward claim, whether it's a whether it's a class action or not, and either recover the loss because of the defect of the product, or recover the loss that you have suffered as a personal injury. But when it comes to the personal injury component, it's often just simply not recoverable because of the threshold levels of injury that you have to meet, as I was talking about before. So, the basic idea of the consumer law, which is to provide a not completely without limits, but somewhat no fault, or at least no need to prove negligence scheme in which you can recover, has been very much watered down by tort reform.
Annette?
I think that the ACL has an important role to play, and I think it does a good job in many respects. I agree with some of the comments that Julie's made. I think that's why tort reform was implemented. If I could talk about that pendulum again, it was viewed that perhaps it was too easy, and so reform was passed to throw up some hurdles, and maybe there's something in the middle that has to happen there to make the laws more effective and make remedies more effective to drive conduct. That having been said, though, what I will say about the ACL and some of the obligations on manufacturers and suppliers are that the improvements that were made in 2011 were welcome. They did help in a number of ways. For example, the mandatory reporting obligation is a really important obligation that's imposed on anyone in the supply chain. You don't have to be a maker, you don't have to be what we would traditionally think of as a supplier of a product. I think that one of the barriers to that tool, I mean, the idea of the mandatory reporting obligations, for those of you who don't know, it's to make anyone in the supply chain from go to woe, if I could put it that way, needs to inform the ACCC if it is believed by someone. It doesn't have to be believed by the supplier themselves. It can be a person who's injured or someone reporting this information to them, that a product is associated with a serious injury or illness. And a serious injury or illness is basically something that means you need to seek medical attention. There's some limits on what medical attention means, but that's the guts of what the obligation is. If that comes to your attention and you're in the supply chain, you must report it to the regulator. And the whole point behind this regulation is to serve as a canary in the coal mine, so that the regulator hears about these things sooner and can spot patterns that an individual maker might think, oh, well, it's one thing. I think, this is not associated with my product. Clearly, this person didn't need to go to the doctor, for example, or clearly this is not a serious injury, or really what was wrong here is they didn't follow the instructions. There's not a problem with the product. It eliminates all of that discretion and makes sure that the regulator gets early warning of things that are happening so that they can spot patterns, nip issues in the bud. So that's a good thing in my view. The problems are, and I'm using this as a microcosm, I think, and to perhaps echo some of the things that Julie said, is that it doesn't quite go far enough in some respects. So it gives us that tool of early reporting, and yet doesn't go as far as every other Western jurisdiction in the world in extending it to risk-based reporting. So you only have to report if the thing occurs and causes an injury. But if, for example, there's a defect in your vehicle that causes you to nearly die, that's okay. We don't have to report that one. Near misses are not reportable. What we need is a risk-based system, and what we also need is a bit of a bigger stick. So I'm quite aware of a number of views out there about when you should and shouldn't report, which are clearly contrary to what the letter of the law is, but people play fast and loose with it because the fine for not reporting something is exceedingly low, and there's not a lot of policing going on because of the resourcing issues. So you can have the best laws in the world, but if you don't have the resourcing behind them, and if you're not thinking about their full effect and how you're going to follow them through, it's not quite effective enough. So in summary, I'd say we've got some really good tools in the ACL. The recent reforms were welcome, hasn't gone far enough, and we've still got some homework to do.
Thanks for that, Annette. Kate, do you have a view about the changes?
Nothing really that hasn't already been expressed. I'm saving my fire for the discussion about litigation funding.
Well, that's a couple of questions away.
I'm sure I'll find something to say before then.
The other related question asks whether companies are now more vigilant in fulfilling their continuous disclosure obligations as a result of the increase in the prevalence of product liability class actions. And I suppose that's something that might require some input from someone with more inside knowledge of the relevant industries than might be available here tonight, but I'll ask our panellists for their view anyway. Do you have a view about that, Annette?
I would say I have a view right up until you get to the product liability part. So I would say there's been a profound effect on people thinking about their continuous disclosure obligations as a result of class actions that have occurred in Australia. I wouldn't say that it's necessarily because of the product liability class actions. There have been a plethora of actions and proceedings around whether a disclosure should or shouldn't have been made, well, it's mostly should have been made and was not made, or whether the disclosure that was made was incomplete in light of continuous disclosure obligations, which give strike fear into the hearts of a great many directors around Australia, myself included as the chair of a board. and I'm not saying that's a bad thing, but I do think that companies are are more vigilant because they see what can happen if they get it wrong and how serious that is. Not to say that they wouldn't take it seriously in the first instance, but I do think that it's caused a bit of alarm, and with that comes vigilance.
Do you have a view, Kate, about whether any of that sort of vigilance, which has been prompted by shareholder class actions, has filtered down to the product liability area?
Not really in my experience, simply because the cases that I've been involved in or that I've looked at recently are not against listed companies. So obviously that plays out there. But I have noticed an interesting development in the United States as a sort of satellite form of litigation when a product liability case is looming or has been issued or has reached a significant stage. Then arguably it's the obligation of the defendant company that's listed to report that to the market and to let the market know, if the case is, if settlement has been agreed or how much, and what the kind of long tail implications of that are for its cash flow and so on. I'm not 100% about this, but I think that in the United States, Merck has been the subject of a shareholder class action because it didn't properly disclose the extent of its obligations to pay under the Vioxx settlement in the United States, which is a very, very different settlement form to what happened in Australia. And in the US, the case against Vioxx was successful, and there was a very large fund created that had all sorts of not just cash payments but medical monitoring and this sort of ongoing need to come up with cash, not dissimilar to what happened with James Hardie here in Australia, which is probably the original product liability case for all of us. So I think that there are continuous disclosure issues that are associated with product liability class actions, but they tend so far to follow a class action being issued and proceeding through the stages rather than being a sort of preemptive form of continuous disclosure. I haven't seen any real connection between the potential for a product liability class action and disclosure obligations in this country. But I think, again, partly that's to do with the fact that there just aren't that many publicly listed companies in Australia being sued for defective products, which is, a good thing. If people aren't being injured, that's a good thing.
We might see it in the context of, we might ask our friends at Honda and Toyota what they think about this issue, because we've got a class action issue with the Takata airbags. Every time you pick up a piece of news about it, the number of airbags affected seems to multiply. They're off having babies somewhere. I don't know. It's getting like an airbag. It's virtually exploding. I'm just full of wonderful puns this evening. But I think that's a context where it might come up where you can see, that you've got a product that is defective and you're trying as a company to get a grasp on how big is this potential liability and how much is it going to cost me to do that recall. And once that number gets to be material in the context of the listed company, that's where it can get tricky. But those are relatively rare, I think. Sorry, Julie, you were probably...
Julie, do you have a...
I don't really have a view about how it's actually working in practice because, I'm always on the other end of it. And being on the other end of it, you always hope that your work has a wider or does good in a wider sense, and that wider sense, not just benefiting the individual client you represent, might be that companies look at the conduct and amend their ways, or other companies look at what happened and take it as a cautionary tale. At the same time, though, you don't actually want companies to act well only because they're scared of litigation or only because they think that a class action might be forthcoming. You want them to act well because it's the right thing to do. And I suspect that most of the time that's right. I don't think that anybody flouts the law blatantly hoping that they'll get away with it. And, the fact that there is the consumer law there, it means that they've got those obligations to act correctly. It's nothing without without the potential stick at the end of it as well, which is that there might be a suit. So, we live in hope, but I'm not sure of the actual the actual impact on the ground.
Well, that brings us now to this issue about litigation funders. The seventh question that's been posed is the current Australian litigation funding model a deterrent for these types of actions compared to the model used in other countries such as the US or the UK? And Kate's already indicated her enthusiasm for this topic, so I'll ask her to start.
I don't really think it's a significant deterrent in the sense that litigation happens and it's still happening. But I think that, as drawing on points that we've already raised tonight, I think what is a deterrent for these sorts of actions, certainly on a class action scale, are the thresholds and the caps on damages under the Wrongs Act and under the Competition and Consumer Act. And what that means is that really the main players in this space tend to be repeat players. It's rare to have firms other than Slater and Gordon and Morris Blackburn issuing product liability class actions, because not only are they experienced, they know they know the area very well and they know the pitfalls to avoid with this sort of funding model, but they have the capital to run it as well. It is a huge risk for a law firm to punt one of these claims and hope that it pays off a couple of years down the track. So I think that actually what the deterrent is in this sense is the inability to fund it properly. There are, of course, as you all know, several commercial litigation funders operating in Australia. To my knowledge, they have not often, if at all, been used to fund personal injury class actions or personal injury cases really at all. And I think Julie, I'd be interested to hear what Julie has to say about that. In terms of how it compares to the United States, I think the main differences with the United States is not that they have quote-unquote contingency fees and we don't, because we do have contingency fees in Australia. No win, no fee fee agreements are a form of contingency fees, and we have litigation funding that takes a percentage of damages. So really that's been in place for a long time. The main difference in the US, I think, is that there are no or very limited adverse costs, that all trials are by jury with some small exceptions, but that's your constitutional right. And that there are punitive damages. And those three factors radically change, I think, the landscape of litigation in the United States and what make it so different to how we conduct litigation in Australia. In the UK, my knowledge of the UK model is very small. They don't have class actions, or maybe they do, but only in the last year or so. But what's quite common in the UK is adverse costs insurance, which is, and I think that's starting to happen here in Australia as well. So my view is that the way litigation is funded in this country is really pretty similar in a lot of ways to what's already available in the US. And there might be ways, and there probably are ways to finesse that. But the real point of difference comes down to these three factors: the jury trials, the availability of punitive damages, which actually make it worthwhile to run a big case, and the absence of adverse costs. And it's that last one that I think is the real difference and what really drives perhaps some of the concerns about litigation in the United States. I have never heard anyone in Australia suggest we get rid of adverse costs. And I can see some people looking horrified that I've even put those words out there. But in the Fair Work jurisdiction in Australia, there's no adverse costs, and that's a really interesting dynamic, and it's interesting to see how that plays out. I can't really imagine that happening, though, for general common law litigation in this country. And so I think for everybody who's worried about Australia becoming too much like America, if you're worried about it for litigation funding reasons, then we're already here and we've been there for 10 years at least. If you're worried about it for adverse costs, I can't see that I don't have a crystal ball, but I would be astonished if any government got rid of adverse costs in this country. And that really drives why people litigate and when they litigate.
I'm only going to say 10 seconds worth and then hand over to Julie, which is, I agree with 9/10 of the comments that Kate made, but I do still think that the contingency fee arrangements that are available in America do differ from the arrangements that are available here. There's a much larger upside. You can take a much larger share of the pie. And the other multiplier for the factors that you've identified, which are quite rightly user pays, the cost risk, and a much smaller upside, are population multipliers. So the sizes of the classes that you can get and the sort of forum shopping that you can do as well. I mean, for example, product liability mecca is Jackson, Mississippi. Who'd have thought, right? And there are a lot of other states where it's not such a product liability mecca because the common law in each of those states is different. But there are enough people that makes it a big payoff.
Yeah, I'm just thinking about the Johnson hip replacement class action that's on at the moment, which is viable because that particular brand of prosthetic hip was the most popular one in Australia. But there's this sort of slew of other prosthetic hips that probably have the same, if not very, very similar problems in that they're metal on metal and they potentially cause early failure rates as well as possible toxicosis of the blood because of the tiny particles of metal that are used in the prosthesis. But the problem in Australia is that all of the other brands of prostheses were used only, in very, very few cases. So it's just not really viable to go after any of the other manufacturers in Australia because you're only going to have a handful of people who are affected by it. And, out of the people who are affected, you might not have any who have the highest level of damages. Most of them might just need hip replacements. So it's going to be operation costs and, a little bit of out of pockets and loss of earnings. Whereas in America, there's class actions for every single, as far as I'm aware, every single metal on metal hip prosthesis. In terms of the litigation funding in product liability cases, my firm certainly has not ever had a litigation funder for a product liability or any personal injury class action. I don't think, but I don't know for sure that Morris Blackburn has either. I'm not aware of them. And the other firms that occasionally sort of enter the waters, I know Arnold Thomas Becker just settled the Canapés class action, which was the Parkinson antagonist drug that caused disinhibited behaviour, I suppose, sort of sexual promiscuity and gambling and, those kind of things. My understanding is that they funded that as well. So it's certainly something that the litigation funders haven't been keen to get involved in. And I think it's partly because of the caps on damages and all of that sort of stuff, and partly because of the difficulty in drawing up a nice spreadsheet, being able to show exactly how many people, what the losses are, what the upside is, when you look at the distinction between a personal injury claim and a shareholder class action. Whether that will change, I'm not sure. I mean, in some ways it might mean that there is greater access to other law firms as well, not just the big players, to be able to get involved in the space and do things. We are seeing that a bit more. If you look in the lists, there are a few sort of smaller law firms and non-Melbourne based law firms who are starting to do it. And, I think it's, provided they do it well, it's a good thing to have more people getting involved and running class actions because everybody brings something a little bit different.
If I could just make a comment on the matter of adverse costs that Kate mentioned, the absence of an ability for a successful defendant or respondent to recover costs from an unsuccessful plaintiff or applicant has always been a feature, or historically almost always been a feature of Australian industrial legislation, so that people suing for underpayment of wages or non-payment of annual leave or various forms of wrongful dismissal or unlawful termination have been able to do so without being at risk, by and large, of any liability for the employer's costs. the exception is if the action is deemed to have been brought frivolously or vexatiously, that there is a discretion in the court to award adverse costs upon that finding. But that happens from my experience and observations, less than 5% of cases. So the question really arises, if you had a similar regime and the criticism that's now made, particularly with the expanded ability of former employees to sue for wrongful dismissal or various forms of discrimination, is that that's encouraged a proliferation of actions, some of them not very meritorious. So that the question that arises is, if you do away with the liability for the other side's costs, is that going to lead to a similar proliferation of unmeritorious or speculative actions in the hope of that an employer faced with a respondent, a defendant, faced with a likely liability for its own costs of, say, 20 or 30,000, and I'm not talking about class actions now, but in an individual action, is likely to pay over $5,000 or $6,000 or $7,000 just as what's called go-away money. And that's a general question in the context of product liability claims. I'm not sure that it has particular relevance to class actions, because the procedural complications and what has to be done to launch and maintain a class action is probably sufficient deterrent, even if there's no liability for adverse costs. Well, that leads us, I think, to the next question, which is, will the High Court lifting the prohibition against litigation with the High Court lifting the prohibition against litigation funding, should we expect an increase in law firms establishing an associated funding company? And since that trenches to some extent on the general question of litigation funders, I'll ask Kate for her views on that one.
Well, I've assumed that the reference to the High Court decision is to FOSTIP, which was handed down in 2006. So we can actually answer that question by looking at what's happened in the last 10 years. I don't, because I'm not a solicitor and I haven't been for a while, I'm not actually sure of what is going on out there in that area in terms of whether law firms are setting up associated funding companies. The most recent case that I looked at involved Mark Elliott, who's former solicitor at Minter Ellison, who I think has now left, started his own firm, and he has an associated litigation funding company, and he is keeping the Supreme Court very busy deciding all sorts of procedural and interlocutory matters as he attempts to get numerous class actions off the ground. He practices in the shareholder space. And the Supreme Court at the end of last year handed down a decision that restricted Mr. Elliott from being being lead plaintiff and litigation funder and solicitor on the record. They said that was too many hats. And I think he's tried various permutations of that. He's tried to wear multiple hats several times, and each time the Supreme Court, constituted by a different judge, has said no. And most recently said not only can he not do that, but he also can't brief the counsel that he wanted to brief, because that barrister's wife was a 50% shareholder in Mr. Elliott's litigation funding company. So the message from all of that being don't cross-pollinate your activities, I think, when it comes to being a law firm and a litigation funder. at least don't do it without extraordinarily careful and considered advice from, I can't think of how many lawyers and accountants you'd need advice from. The point of that is, of all of the little anecdote, is that it's a high-risk venture to set up practice and have to be practicing and have an associated funding firm. So I think that's one of the reasons why we haven't seen very much of it. Perhaps Annette and Julie will be able to add a little bit more from their perspectives.
Without a great deal of elaboration, I think the answer is yes, we will see it. I just think it's taking some time because, as you mentioned, Foster's was quite some time ago, but we have seen an evolution of things over that time. We've seen liberalisation and more clarity around just what it means that you can fund litigation, where the pitfalls are, what you can and can't do, where are the lines, where aren't the lines, those sorts of things have started to play out. We've also had, obviously, some calls for law reform, which might see a further liberalisation. But I know that private law firms are looking at ways to fund litigation, but avoid the pitfalls that Mr. Elliott has allowed himself to fall into, perhaps unwittingly in some ways, or just testing the boundaries, I think, is what he's doing. And in some ways, it's great because he's showing where the lines are so that others know where not to tread. And I do think that we will see funding models, perhaps not a firm funding a litigation where they're on the record.
Look, I think that there probably will be some change. I mean, one of the issues for a firm that's looking at running a class action, and one of the attractions of having a litigation funder, is to spread the risk so that, you know, you're getting paid while you do the work and the litigation funder bears the risk. If you're the litigation funder as well, then it's not that much of an advantage because the only real upside is that litigation funders might be able to charge, a contingency fee type fee rather than just scale or scale plus uplift or whatever. So, I mean, a neater way might just be to allow actual contingency fees, as per the American model, and make the upside of bearing the risk more attractive. Otherwise, it would have to be some very careful and attractive arrangement that was put in place to mean that the law firm that has a litigation funder as part of its sort of entity wasn't still just bearing all the same risk as before.
So it wouldn't be able to, that's why I'd say not acting in the case. I think there are a number of legal specialists out there who aren't unlike Mr. Elliott in thinking that they are good at assessing what's a good case and what's not a good case, and why should the litigation funders have all of that income? I could put it that way.
And I think that IMF in particular, who are one of the biggest, if not the biggest litigation funder in this country, they have lawyers on staff, and they probably, like many insurance companies, and they play a pretty big role in assessing the quality of cases. For people who don't know, when you present a case to a litigation funder to try and fund it, you do need to have. You need to have probably a draft statement of claim. You need to have a good sense of loss. You can't just say, we think this is terrific and it's going to make $10 million. You're going to get $10 million in damages. You need lots of documents. You need lots of spreadsheets. You often need counsel's advice as well. And the funder will look at all that and consider it like any investment or like any responsible investment decision. So, and I'm sure that's what happens internally in law firms as well when considering whether or not to fund it. It's rare, if not non-existent, that somebody just thinks, this sounds like a good idea and goes for it. So I think that, the funder-lawyer crossover is there already. But as Julie says, why would you fund it yourself when you could get somebody else to bear the risk?
I think I read somewhere that litigation funders only fund about 5% of the cases that come to them. So they're turning away a lot.
For everyone who's concerned about unmeritorious claims being waved through because funders think that they're a good deal, you should take comfort from the fact that funders reject a lot of cases.
I think also that the division between the law firm that is responsible, in effect, for initiating the action or receiving the original complaint, making the judgment that there is a case, and the litigation funder, is that it introduces an element of objectivity which mightn't be there if part of the decision about funding is taken by the same lawyer or group of lawyers who's enthusiastically taken up the action. And I think, of course, this happens under the present system with no win, no fee cases, but they're on a much smaller scale than the sort of class actions that we're talking about tonight. And I think there is probably a need for that wall, if you like, of objectivity between the solicitor having the carriage of the action and the funder. Do members of the panel have a view on that?
I think we'd all agree with you. Yeah.
That brings us to the question number 8. Why have the recommended Victorian Law Reform Commission changes from that, as revealed by their 2008 report, not being implemented? I must confess I'm not familiar with the recommendations of the Victorian Law Reform Commission on this question, so I'll throw this open without further inquiry to the panel. Annette, do you have a view?
I've got a few of them listed here from an article I wrote a couple of years ago that I'm sure everyone has read in the audience, just as relevant for the funding issue and class actions. The recommendations included that law firms offer clients the choice between percentage-based fee agreements and other methods of calculating fees, that percentage fee agreements be approved by the court at the conclusion of proceedings, that there be a means for percentage fee agreements to be varied where there is a material change in circumstances in connection with the proceedings, that there be a cap on the maximum percentage fee charged or a sliding scale of permissible fees which decreases as the amount of recovery increases, and the existing legislative right of clients to have a costs agreement be set aside where it's not fair or reasonable to be retained, so fiddling with the costs as well, agreement issue. Percentage fee agreements be regulated by the Law Society, Bar Council, and/or Legal Services Commissioner. So those were the set of, I think.
And I think there was a recommendation, wasn't there, about the establishment of a justice fund, which was a sort of legal aid for class actions, really. That the court had a much greater role in administering and sorry, it wasn't the court who administered the fund, but I can't remember the detail of it, but there was the creation of this fund using public money that could be accessed by people who wanted to issue a class action but couldn't afford it.
Yes.
And to anyone who's ever had anything to do with legal aid, it will come as, I think, the answer as to why that quite good and interesting and creative idea hasn't been developed is because legal aid funding in this state and in this country is at woeful levels. And I would be astonished if any government wants to pour money into to allow class actions to proceed.
I think the idea of the Justice Fund was that it would be self-sustaining in the sense that if you were successful, a percentage of your winnings went back in, sort of like how the law aid modelling in personal injury litigation works at the moment, right. But it would require an injection initially from somewhere, presumably government. There was also some other recommendations around changing the legislation to ensure that not every group member had to have a claim against every defendant. Yeah. But it hasn't really been necessary in the sense that class actions are able to operate in that way anyway. And I think that some of apart from the cost issues.
The ones about the contingency fees. That's the only ones I read out.
Yeah, the contingency fee ones are obviously the sort of most controversial and haven't been implemented at all. And I guess that's probably because there hasn't been any government will to implement them. But some of the other sort of recommendations were picked up to some extent, at least by the civil procedure reforms, the kind of interventionist role that the court can take in ensuring that practitioners conduct things ethically and appropriately was so much, was strengthened so strongly by those reforms that there probably wasn't that need to do them in relation to class actions separately.
Yeah, and the Productivity Commission has said essentially the same thing as the Victorian Law Reform Commission has. So I'm not sure that we actually have an answer to the question yet, other than that it's still being looked at, and that there are some. It's a very divisive topic. People feel very strongly one way or the other about the topic, and when things are like that, it's very difficult to get enough political consensus to make a change. I think that's part of the issue. Just to sort of throw a wild card in there, I don't think this is going to become a big thing, but I've noticed an interesting sort of development in terms of crowdfunding litigation happening. People have gone out there and said, this particular thing happened to me, I'd like to bring a claim, but I can't afford to bring litigation. Does anybody want to support me to bring this litigation? Which is a whole nother take on the access to justice issue. I don't think that a lot of funds have been flowing in so far, which is why I say I'm not sure it's going to take off. And how would what would misleading and deceptive conduct be? Is that in commerce? There are all sorts of things that you can see arising from that. But I guess I just raised that to say that sometimes where there's a need for change, the change doesn't always happen through legislative reform. Sometimes people just get into the market, and really that's what litigation funders did before FOSTIF. So watch this space, I suppose.
I think someone's trying to crowdfund at the moment for Greece's debt. I read that today. So maybe if people are willing to pour money into something that seems like a dead loss, who knows what effect that might have, or what trend that might be starting.
I think several people in Europe think that's what they've been doing already. Sorry.
The IMF crowdfunding.
The IMF crowdfunding.
Well, I think the next, the answer to the next question is in part already emerged, but I'll put it anyway. It is whether contingency fee agreements would open the floodgates of litigation in a comparable way to that which has occurred in the United States. The impression I get from the contributions of the panel so far is that it's not contingency fees that restrict or regulate the volume of product liability class actions, but rather it's a complex of other factors, including the population affected and various other matters. But I'll throw that again open to the experts.
Yes, I think you've summed it up quite nicely. The only thing I would say is that I do think you would see an uptick. I don't think you'd see the floodgates opening. I think it would make an impact and provide some access that would not otherwise be available to the courtrooms. But I think the whole floodgates argument is completely misconceived because there are so many other factors that impact on why there's so much product liability litigation in America that don't exist in this environment.
I agree completely.
So do I.
And then the 10th question is, who are the real winners in product liability class actions? And I suppose that is in part a philosophical question, but and it may be something that the members of the audience have views on too, but we'll hear those shortly. But Annette, do you have a view about the real winners?
I think that's a tough question, to be honest, because there are a number of ways I could think about that. Look, I think I'll answer it in this way and say that I think that there's a role, and we sort of touched on this at the outset, that there's a role for product liability litigation, be it through class action or otherwise, to play in enforcing the laws of the land. We've seen this sort of thing in lots of other areas, and it doesn't make us cringe necessarily. We've seen ASIC, for example, say that there's a role of litigation to play in enforcing the corporations law. So I guess I see the Australian consumer law in the same way, that there's a role for litigation to play in regulating conduct. That's always been the case. That's how tort law was born, and all of the common law countries follow that tradition. I just think that that role could be served better here, where there more access to that litigation. And I don't think that it's probably no mystery that I largely act for defendants in this arena. I don't think that I'm doing my clients as defendants in this sort of litigation a disservice by saying that, because where that litigation does play out, the grey areas of the regulation have light shone on them, and where obligations end and become more clear. A test case being run in respect of hip implants for one company that has a lot of products can give the other companies in that area more clarity around what conduct is okay and not okay. I think there are extreme cases where it's very easy to recognize the right conduct from the wrong conduct, and then there's a lot of gray area. And so I think there's a role that the litigation can play in shining some light on that as well. I think everybody in society actually gains from that, because at the end of the day, we're all consumers living in this country.
Yes, thanks, Annette. Well, Julie, from the plaintiff lawyer's perspective, who are the real winners?
Well, in the class actions that are related to product liability that run, there really haven't been that many, and so I do take Annette's point that consumers should be the winners. They would be bigger winners, and we all would be bigger winners, I suppose, if some of the impediments to access to justice didn't exist. But I think that in the absence of class actions as a mechanism for bringing these sorts of claims, the vast majority of them wouldn't be viable at all. So imperfect as it is, it's better than nothing, and it certainly has been good. I think that litigation definitely can shed a light on certain aspects of the law and how it should be interpreted. Sometimes that light results in an opaque result. I still would like to understand the legal position in Australia on causation, for example. If anyone can explain it to me, I'd be more than happy to hear it.
I'll know it when I see it.
Because following the full court of the federal court's decision in Vioxx, which hasn't been overturned, so in one way is still the law, but then there's also the High Court's decision in other cases, Amica and Ellis amongst them. I'm at a loss. So I think that it's a work in progress, but hopefully at the end of it all, trite as it is, we'll all be the winners.
Kate, do you have a view to sum up that question?
Not a particularly considered view. I think lawyers always win out of this, out of these cases. I agree that consumers do well, could and should do better. But lawyers get paid no matter what happens, and
not always.
All right, no, that's true. Maybe I'm just thinking about counsel, no. Look, I think the comments that both Annette and Julie have made, I agree with them completely. The result to consumers is imperfect, and there's room for improvement. But certainly, I think that overall, Australia is a very safe country to live in. We've got generally very, very good regulation, and in part that is a result of product liability class actions, and we should be, we're all a little bit safer because of that. I think that's good.
The last two questions bring in the question of technology, and we can avail ourselves of Kylie's expertise in that area. The first question is, what is the role of technology in a product liability class action, and how does this differ from other types of litigation? So perhaps, Kylie, if you'd like to start.
Sure, well,
there.
perhaps it's easier to start with the general proposition in terms of the role of technology in litigation generally. And obviously it has a multifaceted role, from evidence acquisition through to management, procedural compliance, analysis, preparation for hearing and at hearing itself. So many types of technologies have roles in relation to these various roles. So you have evidence processing technologies, acquisition technologies first of all, and evidence processing technologies, then the more standard litigation support type technologies, some of which then extend into hearing room technologies themselves. So, as I said, these are fundamental technologies that are relevant to all types of litigation, really. And I guess their role just becomes heightened in the class action area, and particularly so in the product liability sphere, which, as the panel's already discussed, has its own complexities and has its own limitations in terms of thresholds and costs that damages may be awarded. So I think there is a high reliance on that technology to prove itself in terms of adding real efficiencies. There's a need for the technology to be self-sufficient to the extent that it can be. Obviously, there's not an unlimited scope in terms of what the party is prepared to pay to support the technology. And certainly when you have firms funding litigation, they're going to be looking for very cost-effective technology models that can be implemented, potentially over a long period of time. So I'm sure that these litigation technologies form, I'm sure that Julie and Annette's team use these technologies every day in terms of managing the needs of the class participants, the details of the class participants, and managing the evidence itself. And they really do become fundamental tools of trade for litigators working in this area. So the technologies are extending every day. You know, we see technologies available today, for example, in terms of analytics style technology, which offer new horizons to litigators in terms of their ability to analyse really extended potential sets of potentially relevant evidence. So those really can level the playing fields in terms of the grunt that is available to legal teams. So once upon a time, I think it was just throw more junior lawyers at an evidence management challenge to try and work through vast sets of materials. Now the technology really lends an upper hand in terms of the tools that are available, analytic style concept searching, for example, clustering of files on the basis of the concepts involved in those files, email threading, near deduplication. These types of tools allow for sets of evidence to be filtered down to potentially relevant subsets, and also give a leg up to the legal team in terms of the analysis of those materials. So I think, as I said, I'm sure that I know that both Julie and Annette's teams would treat this technology as a tool of trade for them on a daily basis. The other thing that's relevant in noting in the class action sphere is that some of these more clever technologies also allow for more efficient management of common class data and specific claim data. So you get models now that are available, say, to manage a common core of evidence that's relevant to the entirety of a claim, and then, say, satellite treatment of specific claims that are relevant to the common claim. So this provides greater integrity in terms of management of the evidence, and greater cost efficiency and flexibility in terms of dealing with the specific claims from members of a class. So these are the kind of advances that we're seeing that do change dramatically the cost of running this litigation and the availability of these types of tools to a wider range of firms as well. So it's not just, I know we have a very standard players in this area, but the technology does open the gates to smaller players to get involved and have some of the advantages that have been more typically available to these larger firms.
Thanks for that, Kylie. If I could just intrude one question, and I'll throw it open to the other members of the panel. What's the optimum point in the process for introducing the technology, and what's the capacity of the technology to be modified or adapted as the case develops? Would you like to make a few first of all, Kylie?
Yeah. Yes. Well, we have our clients use technology. Well, the ones who most effectively use technology use it from the very beginning. You know, if you're going to get the cost efficiencies and the time efficiencies that the technology offers, you really need to start as you mean to go on. It needs to be utilised from the very outset of a matter. The worst case scenario is when at some further point down the track, the party makes a decision or the court imposes a requirement to use technology, and that's not been done in the early stages of the materials management. So the optimal time is early. In an optimal situation, particularly the defendant client has used technology to effectively manage materials and prior to litigation, so that those can be accessed effectively even prior to the litigation commencing, and those can be managed and analysed in a way that doesn't incur unnecessary cost. So yes, early is definitely best in terms of time frame.
Annette, do you want to comment on technology generally?
Sure. I guess I would say I agree with that. I mean, the issue, some of the issues and the teething pains that existed around, agreeing formatting and all of those things early on in a proceeding are gone, because it's quite easy to use multiple formats, and then once you have something in electronic form, it's much easier to change format midstream if you need to. It's very common for something to be held in a database in a form that can be PDF searchable, also in TIFF, and the extra cost of holding things in different formats has really gone down. So I think if I was going to spot a trend, because I'm quite old, I can say that over the last 25 years of doing this, the changes in technology are profound. And so the ability now in an environment that is increasingly becoming paperless for more and more organizations, including law firms, but importantly for clients and large corporations, the ability to manage all of that data really does turn on the ability to use technology effectively. And so tools like intuitive tools to find issue spot, group issues, to find all the documents related to a concept or a theme more effectively. It used to be that you'd walk into archives and there might be a whole wall of boxes and you had to somehow find the most relevant documents in that. It's easier with technology to do that. The one thing I would say, though, is that there seems to be a perception, we've all heard a lot of the debate around the costs of litigation, and just a number of quotes in particular after the C7 litigation about proportionality and how the cost of litigation needs to be proportionate to the amount in controversy. I think that all of that is true, and I think technology has come a long way since C7, so it is now much more cost effective to use technology in cases. But I would just caution to say that junk in, junk out still applies, and no matter how great the technology is, it's not a magic bullet. So you do need to think at the beginning about what it is you're trying to accomplish, what it is that you're setting up the system to do, what rules and parameters you're putting in place to get out what you need, and how that's all going to work down the track. Because if you don't, I think the comments that were made earlier are very profound. It does end up costing you more in the long run. But if you think carefully about it, you save yourself a great deal of time, trouble, and a number of trees. So.
Yeah, certainly one of the first steps should be development of a workflow that the team is going to adhere to.
Well, Julie, your firm is one of the bigger ones that have already been mentioned. What's your view about the introduction and management of technology?
I was going to say I couldn't imagine running a class action without one, except that I can, because we did, and that was the Oysters and Great Lakes Council class action back in the late 90s, and my recollection of that is every day traipsing off to court with trolleys and boxes full of documents, and then junior counsel would turn around to me and hiss at me, and I was junior lawyer, and I'd flick through 100 pages and desperately try and find the tagged thing and hand it up, and it was an absolute nightmare. I was, incredibly stressed. I think I got all my grey hair then, and I was only in my 20s. It's an enormous boon, but I couldn't agree more with Annette about the junk in, junk out, so that the temptation is to think that because you've got this amazing technology and, such fantastic ability to do so much, that you should do it all, but if you put in 50 million things about a document, searching it's going to be a nightmare. You still need to read it. You still need to sort of figure out what the key points are and what you want to, what you want to have as the searchable terms and all of those sorts of things. But when you get the parameters right, it's amazing, and it also means that trials just run so much more smoothly because the judge can have everything in front of them, and everybody's literally on the same page on the screen rather than rifling through. So it's changed the landscape for the better, but it has taken a bit of time, and I'm sure it's got a way to go. It's what we're saying about it in 10 years from now will be amazing as well.
Kate, you're probably the end user of all this technology. What's your take on it?
Well, my advice would be to certainly to get in early with working out what technology you need, not just as a firm for managing your own material, but I think it's very important to get the barristers who are going to be involved in the trial in early, because there's no point in designing a system that there are lots of different kinds of barristers, and you might get someone who says, well, I'm just not going to use a computer anyway, so you're going to have to do everything for me in hard copy and send it to me, by carrier pigeon or whatever. And then you might get somebody who's
true, don't laugh.
Yeah, no, these are real stories. You might get someone who is very tech happy, like myself, but who finds that their instructor is running an entire system that can't be used on a Mac. And 90% of barristers use Macs. And these are such basic things, but you need to consult widely with all of the end users of the platform that you're going to be using and the system you're going to be using. So work out what you want, work out who's going to look at it and think about it and put it into the system, talk to the barristers, and as early as possible, I can't urge you to do this more, mention it to the judge. Because what no one wants is what happened in a case I did a couple of years ago, where there were 26 barristers standing up and telling Justice Michelle Gordon that we wanted to run an e-trial, and she said, why don't you just put it all into a PDF? And collectively, the barristers sort of looked all a bit askew, and the solicitors just, colour was draining. You could see the tens of thousands of dollars that had been spent on technology going down the drain. That isn't what happened. It didn't all go into a PDF. We were able to say it needs to be done this way for this reason, but it wasn't perhaps the best example of collaborative, well-organised case management by any of the lawyers. Everybody should have gotten together and worked it out beforehand and presented it to the court early on as, look, here's what we'd like to do and we'd like to do it this way. Is the court able to accommodate that? Does that work for the tribunal? Because you can have the best system in the world, but if the court doesn't want to run an e-trial or they don't want to do it your way, then it's a waste of money. So think about who is going to be using this product at the end of the day and using it to make decisions about how to run the trial and how to decide the trial, and get them involved early.
Good. Well, I think the last question has probably already been covered by a lot of what's been said, but I'll put it anyway in case there are further thoughts. It is, how can technology address the issues the plaintiff and defendant firms face in dealing with these large matters, that being a reference to class actions in product liability cases. So I'll ask for perhaps a quick, succinct response to that from each of the panel members, starting with you, Kylie.
Well, to some extent, the needs are common in that ultimately you need to work your way through a large volume of evidence and, separate the wheat from the chaff, find what you need to find as effectively as possible. Clearly, the defendant starts with that challenge, needing to work through what's generally a high number of, a really high volume of materials to find potentially relevant materials up front. I guess plaintiff firms are often coming from the class management to start with, rather than even before they even have access to the defendant's matters. So there's probably come from slightly different angles, but ultimately both parties then need to work their way through the high volume of materials to find the highly relevant materials. So I think that's the difference and the commonality there.
Annette, do you have a
I would just say it helps you manage that large volume of information in a much more effective way, find what you need from either side, assess the claim earlier, understand what are the key issues, what's the key information, and how that might play out. So it helps you manage what's otherwise a large amount of information in a much more effective way if you get it right.
Julie?
I mean, just really obvious things like if you have all of the group members' details and, you know, all of the different permutations and combinations, when you're talking, for example, in a mediation and you're talking settlement, it's a click of a button to calculate, okay, what does this offer mean for these people? You know, and that's revolutionised the space. You know, before it would be 10 people for an hour with calculators, so...
It also means I don't have to break my back to work at home like we all like to do, because I can log on to a database and have it all right there at my fingertips, which makes my 9-year-old very happy.
Well, do you want to have the last word on technology, Kate?
One aspect that I think is really relevant for class actions is the notice provisions. It's really important that it's a requirement of the rules and of the Act that certain notices go out to class members, that communication with group members and potential group members is effective, and technology, I think, has radically changed that. So instead of having to put big ads in the paper, you can still put an ad in the paper. You can now email a lot of people, you can put things on Facebook, you can disseminate information to group members and potential group members with tremendous ease and at a seriously reduced cost, which is very important as well, because you don't need to pay for a lot of advertising. You're not sending out thousands and thousands of letters and all of the cost associated with that. So I think that it not only has changed the efficiency of this process, but made it much more cost effective, which is terrific.
Good. Well, I notice from the time that we're already running a bit late, and the answer to the last question will have been obvious. It is, do you believe that technology is well suited to running class action hearings electronically? Well, I think it's clear from what the panellists have already said that that belief is unanimous among the members of the panel. So I'll now invite questions from the audience on any of the matters that we've discussed tonight, or on any related issues that perhaps haven't been canvassed that people think the panel might be able to shed some light on.
Just a question to anyone on the panel. One of the shortcomings possibly with the class action process is the inability often of defendants to gauge what a class actually is worth in terms of resolution, and it's a shortcoming in the rules as they stand at the moment, in that there's no process that enables the court to require the class to divulge what how many members they're going to be, what their individual claims are going to be worth. Does the panel have any views on whether that's a need for improvements to be made to the rules themselves, or is it something that should be managed by the bench or between the parties? Obviously, to get to a mediation, you need to have this information available well in advance so that people can obtain instructions and hopefully resolve a case before it ends up going into the trial.
Yeah, look, that's a really interesting question. It is to some extent managed by the bench, I suppose, in that the bench has open to it the ability to make any orders in the interest of justice, and sometimes there have been situations where the class has been closed prior to mediation. In the Fairbridge Farm matter that was just settled this week in New South Wales, so this was an institutional child abuse case, the defendants sought class closure about a year ago, and the judge resisted that. We weren't actually necessarily opposed to it, but the judge resisted it on the basis that he thought that it was beneficial to the defendants to have finality in the sense that once there was some resolution, everybody who hadn't opted out was caught by it. And if class closure occurred at an early stage, that then there would be people who would, I think what he was trying to suggest is that there would be people who would come forward then who might never actually come forward otherwise. It was not really clear to us exactly what the motivation was, but it meant that we did go to mediation with neither side knowing what the parameters of the class were. So we knew how many people we had, and we had a sense of that, but we had to work on an assumption that there would be a lot more people coming forward. I guess one of the, so we did some sort of, actuarial calculations around it based on how many people we knew had gone through the institution and how many people we thought had died and what the rate we suspected of abuse was and where those claims would likely fall on a bell curve, and came up with a figure and managed to settle it. But it's subject to final approval. And if, for example, the figures of what we think will come forward proves to be totally wrong and twice as many people come forward, then that's going to be a matter for the judge as to whether he approves that settlement. So there is that element of uncertainty, I suppose, for the defendants, as there is for the plaintiffs as well, and it is to some extent in the hands of the court. It's a bit of a vexed issue about class closure, because the whole idea of a class action is meant to be that you can have the benefit of sitting back and doing absolutely nothing until a verdict, potentially. I'm sort of not, I'm not hard and fast in my view about it, because I think that there are some cases in which that's clearly the right way to go, and there are other cases where it would be much more useful to have greater certainty. The courts have resisted sort of attempts by, for example, in that spate of actions where there was an attempt to define the group by reference to these people being clients of Morris Blackburn, for example, and the courts just said, well, you can't define the group in that way, so take that clause out. I don't know what I think about it, actually. What do you think, Annette?
I don't think there's a perfect way to do it. If you make it too confined, there are disadvantages to that. If you make it completely open, there are disadvantages to that. I just think there's going to be upside and downside to every approach. I do think Julie's right that the court does serve as a check on the whole thing, and not just in this aspect, but also in approving the final settlement, satisfying itself that the members of the class are properly looked after, for example, by a settlement figure. In order for the court to do that, it has to have some idea of what it thinks it's looking at. So I just think it's fraught with difficulty, and it throws up issues which you've actually very well identified. So I don't think I have anything more to add to that. Yeah.
And I think, unfortunately, for most lawyers, myself included, who are very comfortable with certainty, uncertainty and open-ended questions are part of the beast of a class action, and we all just have to sort of work out how to live with that. Unfortunately, even in a case that I did recently where the class was closed a year before settlement, it didn't stop many, many more group members coming out of the woodwork after the settlement was announced, but before it was approved, and then after the approval hearing, but before judgment had been handed down. And even now that the case has settled, settlement's been approved, and administration is ongoing, there are still people coming forward and saying, actually, I think I might be a member of this class. This is for events going back 10 or 15 years. There is an element to all of this that is simply uncontrollable. And the approach that the courts have taken in resisting attempts to close classes very early reflect that the court seems to be pretty comfortable with the uncertainty. Well, I mean, of course they are, but
It's harder.
That's. I don't mean to be flippant, but it's harder. It certainly is harder for the practitioners to get a sense of the size of the beast. But as there are responsible ways to get around that. Nothing is ever going to be perfect, and those responsible ways have already been explained, I think, by Julie. So
actually, it makes me think, Kate, I was involved in the hepatitis C class action, which was people who were contaminated with hepatitis C from an anaesthetist at a clinic in Melbourne. And we thought we had a very, very good handle on the class in that case, because the health department had done a very extensive look back and had identified the group of people, and the vast majority of them were our clients. But we knew that there was this handful of about 10 people who had been identified who hadn't actually come to us. And so when it settled, we had factored in those people into the settlement, knowing that they were likely to be class members. And the police actually ended up making contact with those people because they had been the subject of the criminal proceedings as well. And those people all eventually did come forward to us. But subsequently, other people continued to come forward and say, actually, you know what, I think I might have hepatitis C. So we'd say, well, go and get tested. Find out if you do. Most of them didn't. Or people would come forward and say, I do have hepatitis C. And and I must have got it from him because I didn't get it anywhere else. And then we'd get the medical records. And as it turned out, there weren't actually any other class members other than the ones that were known to us, although there were a lot of people who thought that they might be. But Justice Beach in that case made it very, very clear that he would entertain any of those cases up until the point that the money was distributed. So even after we'd sort of sent all final notices and everything out to everybody, if someone had come forward and had a viable claim at that point, he made it clear that he would include them.
Any other questions? No? Well, thank you everyone for your contribution tonight. We just have a small gift to give to our panellists as our thanks, and then that will conclude our evening, and we'll ask you to join us at the back for some drinks and some canapés.